All right. Hello, everybody. My name is Milena Vino. I am the Business Information Officer here at the World Trade Centre Winnipeg. I would like to begin today's webinar with our land acknowledgement. We acknowledge that we are gathered on the lands of Treaty 1 territory and that Manitoba is located on the traditional and ancestral lands of the Anishinaabe, Anishinaabe, Innu, Denesalin, and Dakota Oye nations. We acknowledge we're also in the homelands of the Red River Métis and that northern Manitoba includes lands that were and are on the ancestral lands of the Inuit. The World Trade Centre Winnipeg team respects the treaties that were made on these territories and acknowledges the harms and mistakes of the past and present throughout our nation. Thank you for joining our webinar, Manitoba Employment Standards Overview, which will be presented by John Knight. Before we begin, I want to share just a few housekeeping items. So number one, please send all of your webinar questions directly in the chat box. It should be at the top of your screen. And John will try to answer as many questions as he can during the session. And we're also having a Q&A session at the end. Number two, for all logistical questions, please send them directly in the chat box and I will try to answer as soon as possible. And lastly, you'll receive a PDF copy and recording of this presentation within the next week. So now it's time to start our webinar. I would like to introduce you to John Knight. John is an Employment Standards Officer with Manitoba Employment Standards. Welcome, Jonathan. The floor is yours.
Perfect. Thank you, Milena. Hi, everybody. My name is John. As said, I'm an Employment Standards Officer, so I'm going to go through a little presentation for you guys and basically explain what we do at Employment Standards. And as Milena said, feel free to put questions in the chat too. We'll try to get to them as we go, but we'll have time for questions after as well if you want to save anything. So I'm just going to share my screen. And Milena, can you see that? Is that being shared?
Yes, we can see it.
Perfect. Okay, so let's jump in. So first, I just want to go a little bit through employment standards, like what we do and who we are. We're a neutral third party. We're not an advocate agency at all. We do neutral investigations. We basically help employees and employers learn about rights. We do education, things like this, rights and responsibilities in the workplace. We also enforce minimum standards, which apply to most employees in Manitoba through a claims process. Now, I say most employees because we don't cover every employee. Some employers are federally regulated, banks, telecom, transport tend to be federal. We cover provincially regulated employees. We don't cover every aspect of the workplace relationship either. It doesn't cover everything. It doesn't cover independent contractors, for example, someone who goes into business for themselves. It only covers employees. And it only covers certain aspects of the employment relationship, usually things that are kind of wage related. So we'll look at that in a minute. Just a little note here, we'll get into this a little bit later too, but you actually, the Employment Standards Code and Employment Standards does not allow employees or employers to have an agreement where someone is working for less than the minimum standards upheld in the Employment Standards Code. And that just means that someone cannot agree to work for less than minimum wage or agree to forego vacation, for example. So let's look at what we're going to talk about in detail here. These are some of the topics. These are things that you'll find in the Employment Standards Code that we enforce. So you've got wages, ending employment, what happens around termination, resignation, just cause, which is what happens at termination. Occasionally, employers will claim this. Hours of work, overtime, breaks, day of rest, vacation and holidays. Note these are different. Some people tend to mix up the terminology here. Vacation is like weeks of vacation entitlement. General holidays are days like Christmas, New Year's, Easter. The code covers leaves of absence as well. Young employees, and then we'll talk a little bit about RAPA, which is the Worker Recruitment and Protection Act. So let's jump in. We'll talk about minimum wage first. Minimum wage currently It's usually set to go up in October. It just did go up to $15.80 per hour. As said, an employee cannot be paid less than minimum wage. You cannot agree to less than minimum wage. Of course, you can be paid more. And even if you have like a commission agreement or a piecework agreement for your work, that still has to shake out to more than minimum wage. Otherwise, minimum wage would be enforceable under the Employment Standards Code. Minimum wages are different for some construction workers, especially in heavy construction, commercial construction, and there are sort of apprenticeship agreements and journeyman and role agreements in the Construction Industry Wages Act. So that is a separate piece, but normal minimum wage of $15.80 applies to most people, most workers in Manitoba. As I said, you can be paid through a salary, hourly wage, incentive, piecework. There are lots of employment structures, salary, yearly salary, etc. The minimum wage itself is reviewed annually and it's tied to inflation, right? So it has been going up in October of each year. But please let me know if there are any questions about any of this as I go. Payment of wages itself. Now, employers do have to pay twice a month, and wages have to be paid within 10 business days of the end of a pay period. It's 5 days in construction. Wages can be paid in cash. They can be paid in check, direct deposit. They cannot be paid in anything. Actually, these 3 things are defined by the code, and they're the only ways wages can be paid. So they can't be paid any other way. You can't pay wages in cryptocurrency, for example. This last note is something I should emphasize. A lot of employers ask about this. You cannot withhold employee pay. So, for example, if someone quits without notice, if someone steals from the workplace, if someone owes you money, you have to handle that separately. You have to handle it either in civil court with a lawsuit or whatever. It doesn't mean you're allowed to cancel out someone's wages. So if we got a claim where someone was saying, hey, this person stole $1,000, so I didn't pay them their last paycheck, we would still enforce that last paycheck and educate the employer that other amounts owing have to be handled separately. This is just an example of a pay statement. Every pay statement looks different. Pay statements are a legal requirement under the code. Employers do have to offer them, and they have to explain what's being deducted. They have to explain your gross wages, your vacation pay. They have to explain what you're being paid in net. Overtime hours worked, they have to include. Your rate of pay, it should explain. And an employer is responsible for actually keeping and maintaining records. Time worked, pay, monies paid are required by employers by the code to be maintained and kept. Pay statements can be electronic. That's quite common nowadays. You can have them paper if you want as well. Doesn't matter. Moving on, some information about deductions. So we're just kind of going through here some of the common things covered by the code. I'll just mention up front, because we get a lot of calls about this. The code doesn't cover things like wrongful dismissal, toxic workplace, harassment in the workplace. These are sometimes things that perhaps employment lawyers can look at for civil suits. There are some information about toxic workplace and Human Rights Act. They're not things that are included in the Employment Standards Code. So we're only looking at things included in the code. Deductions are one of those things. So what can be deducted from an employee's wages? There are not many things that can be legally deducted from wages. These are 3 of the only things that can be deducted. Stat deductions, of course, taxes, CPP, EI, etc. Payroll errors and cash advances can be deducted. If there's a payroll error, you're legally allowed to deduct this. It's subject to some limitations placed by the Garnishment Act. I believe it's 30% of the net pay is the maximum can be deducted, but that's one reason you legitimately can deduct from an employee's wages. And court orders and garnishments, of course, as well. Anything else, really, there are two criteria that are pretty simple. It has to be a direct benefit to the employee. So it can't just be the employer asking them to do it and the benefit is because the employer wants them to. It has to be something like, for example, education. The employer will pay for your education. The employee wants to purchase lunch every day and the employer says, hey, we'll just deduct it from your paycheck. Like things that are obviously things that the employee is getting and they're not required to buy. This can be deducted with consent. So there's those two pieces, direct benefit, consent. Pretty much everything else would be an unauthorized deduction. And we can look at some examples of that where we get common questions. Even if it's consented, employers cannot deduct for damage, broken goods. An employee got in an accident with a employer truck. You can't deduct that from employees' wages. Faulty work, customer theft, cash shortages, safety equipment. You can't charge for safety equipment unless it's clearly a direct benefit, like the employee is going to own it, it's theirs. Interest, stuff like that, fees. Some more common examples that cannot be deducted, uniforms. We don't see this as a direct benefit. It could be a direct benefit if it's like, hey, you need to buy a black shirt, because a black shirt you could wear outside of work. But if it's something with a company logo, it's really just for the company. So it's not a direct benefit to the employee. So you can't charge for like uniforms. Dress codes are fine as long as they're not like exactly unique to the employer, like something you could never wear outside of work. And they have to be, you can't be required to purchase it from the employer. So again, let me know if there are any questions about deductions. We'll have time afterward to ask questions about things as well. So this is kind of a big topic. Oh, there is a question. I can deal with this right now.
Okay, perfect. Do you want me to read it out to you?
I just noticed this one. Normally you could, but I just noticed this one. So can we deduct if there's an agreement with the union? This is complicated. This is actually a difficult question to answer because the employment standards strictly does not get involved when there's a union. If there's a collective agreement, the employment standards code does not cover that employee. It's assumed that the union will negotiate on the employee's behalf. So it's really a question that I technically can't answer, but the union should still be using the employment standards code to determine what their collective agreement says. A collective agreement cannot undermine minimums in the code. So I think probably the answer is technically not, as long as it's one of these unauthorized things.
Okay, perfect. And then I think Amanda has her hand up. I don't know if you have a question, Amanda?
I do. Are we able to get to it now or should I wait till the end?
Sure. Yeah, we can.
You can ask it now.
I guess when it comes to consent for deducting wages, my example would be employee merchandise that they wish to purchase. So let's say we have freezer jackets or t-shirts, toques, etc. They get one for free. If they want anything additional, they're required to pay for it. If we have an agreement with them to take it off of their paycheck, does that have to be, I guess, written, or is a verbal agreement okay?
And I'm going to try to answer this with respect to all verbal and written agreements for all things pertaining to the code generally, because it's something that comes up a lot. Verbal agreements are fine, except I'll give you a scenario. If we got a claim and the employee said, no, there was no agreement, and the employer says, yes, there was, a written agreement is nice because it helps you with liability. So it can be something that you are easily able to show it in the event that it comes down to proving it. Verbal agreements are fine, but the issue with them, I guess, is that if either party suddenly decides to, that there's a conflict, that they can be more difficult to substantiate. So in principle, you could have a verbal agreement, certainly. I would just warn you if it came to an issue where you had to substantiate it, a written one would make it easier for you.
Perfect,
Was there
thank you.
another question too?
Yes, there was one more in the chat. So someone's asking, can we deduct if an employee gets a traffic ticket while using a company vehicle to cover the ticket?
This is a super question, really specific question, but yes, that's actually one of the, like, I wonder if, I don't think we covered it on here, but there is a very, very specific clause in the Employment Standards Code regulations. By the way, I didn't say this up front, but the Employment Standards website, I'll show all this at the end. The Employment Standards website and the Employment Standards Code are both online. The website has fact sheets on all of this, and the code, it's not, don't be intimidated by it. It's actually fairly readable. So deductions are in the Employment Standards Code regulations. It's in section 19. There is a specific clause about traffic tickets under photo enforcement, that this is an example of an authorized deduction. So I'd encourage you to take a look and see if your specifics fit that criteria, but the answer is yes, that is a very specific example of something that can be deducted. Also, the code specifically talks about traffic camera enforcement. I'm going to kind of like read into your question a little bit more and say, because I've had claims about this, examples where an employee gets a ticket themselves. At employment standards, we generally would not look at that as the employer charging the employee something. So a deduction is a deduction if you deduct it from a paycheck or if you force the employee to pay for it in another way. The code allows us to still see that as a deduction. But if the police charge an employee for something, just like if the employee buys a sandwich, if the employee gets a traffic ticket for speeding, and the employee tries to expense that to the employer, and the employer says no, that's not a deduction. That's the employee being charged by the police for something. So there are some exceptions where we would not look at that as a deduction due to the employee never being charged by the employer or being deducted anything, if that makes sense, and sort of maybe answers a little bit more of your question, Ram.
And there was just one more question. So someone in the chat is asking if there was a payroll error done and we need to deduct overpayment. Do we need approval from the employee for the deduction if it's less than 30% of a deduction?
Yeah, and the answer to this is no. So these are examples of allowable deductions regardless of consent. You would need consent if you wanted to charge more than the 30% under the Garnishment Act. But the 30% figure is basically what you can take without consent, regardless of whether there's consent for a payroll error or cash advance.
Right, thank you.
And maybe let's jump back in here and move along. But of course, if you have any questions related to any of the stuff we're already covered, feel free to share them in the chat. So we can talk a little bit about ending employment, and this is potentially a big topic. Ram, I see you still have your hand up. I just checked the chat. Did you have a follow-up? Okay.
No,
yeah, we'll move on. Notice of termination is required by both parties. We call it termination in the code refers to resignation as well as being fired. So it's just termination of employment. But notice is required by both the employee and the employer. The employee notice requirements are shorter. They're generally 2 weeks. Notice requirements for the employee from the employer, like upon termination, increase based on length of employment. So after 1 month, an employee is entitled to 1 week of notice. You can see here. After a year, an employee is entitled to 2 weeks of notice. After 3 years, an employee is entitled to 4 weeks of notice, and it kind of goes up from there. An employee is required to give notice when they quit. However, an employer cannot withhold wages if they are not given notice. This is something that potentially could be pursued in civil court for like damages or something, but it's not typically something at employment standards that we have like a mechanism for employers to recover any damages for this. And this is just regarding when an employee quits their notice given. Now, notice, just to clarify, can refer to the period of time that's required to like notify someone of the termination of employment. Now, this notice period, for example, when an employee gets terminated, it can be given as working notice, which means that you would say, you know, John, your employment is terminated. You've been here for over a month, so you're entitled to 1 week wages in lieu, or sorry, 1 week notice. So you've got 1 week left and we want you to work it out. Or an employee can say, or an employer can say, we're terminating you today. We're going to pay you the 1 week wages in lieu of notice. That's fine. You can do either of those. And the employer can choose which of those to do. And if an employer gives working notice and the employee says, no, I'm not coming, or the employee doesn't show up for their working notice, the employer has fulfilled their responsibilities. They don't still owe wages in lieu of notice. So I want to make that clear. We do get that question a lot. If you give an employee working notice, you say your employment's going to terminate in a week, and the employee doesn't want to work, you don't have to pay them wages in lieu of notice. You've already fulfilled it by giving them working notice. And of course, wages must be paid within 10 days of termination.
Sorry to interrupt. I actually have a question. Would this just be for full-time work, or is this the exact same for part-time workers?
Yeah, and that's a super question. We get that a lot. Interestingly, and this is, I guess, maybe hopefully answering a lot of questions about this, the Employment Standards Code doesn't differentiate at all about part-time or full-time work structures. So those words are not found in the code. So everything in the code applies whether you work 1 hour a week or 40 hours a week. We have ways of prorating things. If someone only works 1 hour a week, the notice would just be for 1 hour a week. So you would only owe them their 1 hour a week of wage.
Okay.
Yeah. There are a couple exceptions to notice that we'll get into in a moment as well for a couple of kind of employment structures that it doesn't apply to. And let's maybe jump over to that. So there are some exceptions to notice. Just first, I want to clarify the difference between a termination and a layoff. We get questions about this. A layoff is a temporary break in employment, so you don't have to issue notice or pay wages in lieu of notice. You're not firing the employee. However, the code states that if the employee is laid off for 8 weeks in any 16-week period, so it could be 8 weeks in a row, or it could just be like 8 weeks of layoff in a 16-week period, it's determined to be a termination. And at that point, wages in lieu of notice will be owed going back to their final workday. So if you lay someone off and then you don't bring them back in 8 weeks, they're considered to be terminated, and the employer is responsible for their notice requirements, which would be wages. In a case of a layoff, it would be wages in lieu of notice. Going back to their regular. So just to be clear, even if you lay someone off, you say there's not enough work, sorry, and they were working 40 hours a week, then you lay them off. That's fine. You can do that. 8 weeks passes, they're terminated. And let's say they've been there for 2 years. You owe them 2 weeks of notice. You have to pay them 2 weeks of notice based on what they were working prior to the layoff. So it's not like you pay, 2 weeks of notice based on the layoff period. No, you owe them their wages in lieu of notice based on their 40-hour work weeks. I do see we have a question that I can, from Nasir, I could take a look at it. If an employer terminates you on 1 hour notice without any reason, what should be action? Yeah, so there's a few issues here. there's a few issues here. One thing is that as per the Employment Standards Code, an employer in Manitoba can terminate for any reason at any time, as long as they're not like illegal reasons like discrimination or something that might fall under the Human Rights Act. An employer can terminate. They don't need a reason. They don't need a good reason. They can even give a false reason, and that's still not a violation of the code. What they do need to do is respect notice requirements. So if someone was terminated and they were not paid their wages in lieu of notice, and they were not given working notice, my advice would be file a claim with employment standards, and we would investigate that.
I think someone else has their,
is there
yeah.
another question? Yeah.
Yeah, hi. I'm just wondering, benefits. If you terminate a person in the lieu of termination, like let's say I owe them 2 weeks of pay, what about the benefits for the company's paying for?
Yeah, so that's a great question. Employment standards and the Employment Standards Code don't actually deal with benefits at all. So they're seen as like a greater benefit that an employer is providing. So I should mention, you cannot use vacation or benefits or anything to count for wages in lieu of notice. Wages in lieu of notice just has to be someone's gross regular earnings. And so it's up to, like, benefits normally would not be part of wages in lieu at all. Like, you would discontinue benefits on the final workday, and then you would pay them out whatever their regular earnings would be for that period.
Yeah, I was just wondering, because if the employer decides that you continue to work for that those 2 weeks, you would be still entitled to those benefits. But if the employer decides that you terminate today and I pay you out the 2 weeks, then you would not be entitled to those 2 weeks of benefits. That was my question.
I would say that under the Employment Standards Code, you are not entitled to benefits at all. So the employer could cancel your benefits at any time, and that would not be a code issue. It could be a legal issue, certainly. I don't recommend anybody do it, because there are, like, a legal issue means that you could talk to an employment lawyer and maybe your contract states certain things, but we don't look at it as something enforceable under wages, under the Employment Standards Code.
Thank you.
So there are a couple things I do want to mention here. Just kind of. I should mention too, if notice is given by either the employee or the employer cannot change. Like, this kind of references that question a little bit. Whoops. The employer cannot change the working situation. So benefits, the employment standards, it's possible that we would look at that and say, hey, if there's working notice, maybe benefits should be in, but normally this clause applies to, sorry, I'm ahead of myself here. Normally this clause applies to, like, rate of pay and schedule. So if notice is given, the employer is not allowed to then lower someone's hours of work or lower their rate of pay, which makes sense. Like, you can't say, obviously, okay, I'm going to pay out your wages in lieu of notice, but your rate of pay is now half. So as soon as that notice is given, you're kind of like, employees are kind of locked in for what their normal, regular work relationship is in terms of hours and rate of pay. So there are some exceptions to notice that we spoke about a little bit here. One of them is, like, employment for a very specific fixed term. Like for just a project, you hire someone for a project, or you hire someone seasonally. This doesn't require notice after that employment period ends. It's basically almost like notice has already been given, because the end of the term has been explained to the employee. Construction as a whole, construction doesn't require notice. There's no notice requirement in construction. So employees employed in construction can be terminated without notice. Another exception is termination for just cause. This is a complex topic. Just cause is something the employer would invoke, basically stating that just cause is a very high bar. It's basically when something egregious has happened, or there's progressive discipline that has culminated in this behavior that has indicated that the employment relationship is broken and the employer felt the employee could not work there anymore. So some examples of just cause would be like there's been theft in the workplace, violence in the workplace, maybe gross insubordination, or progressive discipline scenarios where the employee has been warned about their job being on the line and the employer has followed through where the employee was not performing their duties. Just cause is the employer's responsibility to substantiate. So I'd say if you're ever claiming just cause as an employer, you do have to be careful to document everything. And well, I would probably call our GI line, make sure that you have some of your things straight about how you handle this. But if you have just cause for termination, then you do not owe notice in that case. If we got a claim from an employee saying, hey, I wasn't paid my wages in lieu of notice, we would speak to the employer. The employer would say, well, they were terminated for a just cause, and employment standards would ask the employer to substantiate that. And then we would make a determination about whether we felt just cause was true in this case. Any questions on that?
Yes, there's one that just came in the chat. So someone says if you have a term employment agreement with an employee and you have renewed it for another year, do you need to provide notice when the second term agreement ends?
This is a complicated one. We would really need to see in an investigation. Sometimes if we've had term agreements like with teachers that have been renewed again, it really depends when the communication happened. If it's just not renewed and you say, hey, we're not renewing you for next year, typically there would be no notice owed. But we've had cases where someone found out that their term agreement was not being renewed at the beginning of the next term. And in those cases, there can be some sort of like issues where they weren't notified properly. So I would say if you do have a situation like that, you really need to be in communication with that employee about what is expected at the end of the previous term, if that makes sense, if that answers your question. And did Sista, did you have a question? If you want to ask it out just without putting in the chat, that's fine too. I do see that there's, is it Shirley? Sista, Shirley? You just unmute. I do see that there's another.
Yeah, there's a hands up. Shirley has her hand up. I don't know if.
There's another question from Nasir that I can get into a little bit. It's a complicated topic, just cause. I see he's saying, could you explain just cause in more detail for better understanding of employees? It's really hard to explain in detail. The code is purposefully gray in this case. It's not black and white. Black and white legislation, I guess in this case, maybe legislators feel that it can be abused if it's very black and white. So it's something really that is a case by case thing. But generally, we look at two things with just cause. Either something so serious happened, like, again, violence in the workplace or gross insubordination, theft in the workplace, something really, really serious happened that the employer feels, or that a reasonable, sorry, Shirley, I'll get to your question in just a minute. I'll answer Nasir's first. That the employer or that a reasonable person feels like obviously this employment relationship has ended, right? Or the other alternative is that it could be a situation where progressive discipline has occurred. And as long as an employee has been warned for generally the same behavior, they've been given an opportunity to correct that behavior, it hasn't been corrected, and they've been warned that if it continues, their job will be lost, then the behavior continues and they are terminated. In those cases, we have upheld just cause as well. But again, just cause is a high bar, and it's on the employer to substantiate when they claim it. So I don't know if that answers your question. It's hard to answer just cause questions in a really simple way because they're really complex and each one is really, really different. But I would say if you are terminated for just cause and you feel that it is unfair, contact employment standards, and it's something we can potentially investigate. And just piggybacking on that with Ram, how many warnings is acceptable prior to termination? This is, again, just case by case basis. I've seen claims where something fairly serious occurred. You know, let's say there was a really serious incident with a customer and there was like abusive language, and a single warning was issued, and it was called a final warning, and it contained information about what happened, and it said, if this happens again, you are going to be terminated, and the employee knew about it and received it and acknowledged it, and it happened again, and they were terminated, that could be just cause. Other situations, maybe it's less serious and, you know, 3 or 4 times. So it's really up to the employer to determine what's appropriate based on the situation. Another thing I would warn you about is we've looked at cases where condoning occurs, where you're warning an employee for something and you say, hey, 3 strikes and you're out. And then they do something 3 times and the employer says, well, you know what, just try to do better. And then they do it 4 times. And then they say, yeah, well, you know what, you really need to improve this behavior or you're going to get fired. And then they do it 5 times and they get fired. That's not just cause, because the employer communication said they would be fired after it happened 3 times, and they weren't. So the employee wasn't properly communicated to in that situation. So if you have a policy, you really do have to honor that policy with respect to just cause claims, because let me just say too, just cause is a serious thing. It involves waiving an employee's basic rights to notice. So it's treated as something fairly serious. So when it comes across our desk, it's serious. So we deal with it on a case-by-case basis. It is difficult to answer in a concrete way, but hopefully that does answer some questions. Shirley, did you want to ask your question?
Yes, thank you so much. I was having a fight with the mic and the chat, some tech issues.
No problem. Hopefully Mike is the mechanism and not a person.
Anyway, I had a question with regards to notice with respect to at will. Am I understanding that there is the employer is not required to give a notice, or they are in at will situations?
Well, at will is not something in the Employment Standards Code. There is one other exception to notice that is not found here, and that's what people call casual employment. So this might be what you're referring to. In casual employment, where an employee is basically like a sub or something who's like taking shifts occasionally, and they can decline shifts, and the employer is basically saying, hey, can anybody work this day? And they say, yeah, I can. In those situations, notice is not required for termination. We look at termination in that case as just kind of like ending that situation rather than ending an employment relationship. Does that answer your question?
No, I was speaking more of in situations where, I don't know of an example, but you mentioned that an employer could pretty much terminate an employment situation without giving any particular reason. In the US, we call that at will.
Right.
And I just wanted to know, do they have to give notice to the employee in those type of situations?
Well, when I say those type of situations, I'm referring to all termination. Termination in Manitoba is not something that requires a reason by an employer, and it's something that the employer can do at any time. So in those senses, I guess it is similar to the American like at-will employment, but in all cases of termination, except for the ones we specifically talked about, notice is required. So
Yeah.
yes, they can terminate for any reason at any time, but they do
Mhm.
have to respect notice requirements.
That's what I needed. Thank you.
Yeah, you're welcome. And let's move forward here a little bit. We could take a look. Okay, so there is a slide here in Just Cause. These are just some examples. They're not the only examples. And just because something happened that you might consider dishonest doesn't mean you have just cause. Everything is situational with just cause. There's a lot of context involved in these situations. So again, there's a high standard. The onus is on the employer. Each situation is considered individually if we get a claim across our desk. And again, it could be a single sort of incident, or it could be a culmination of some kind of progressive discipline scenario. I do see that we have another question in the chat from Kathy. If employees are located in another province, yeah, that's a really interesting question. So that applies to all the code. Employment standards codes in Canada apply to the employee. So if an employee works in Saskatchewan, they would be subject to the Saskatchewan Employment Standards Code. If an employer is located in BC, but their employee works remote in Manitoba, that employee would be subject to the Manitoba Employment Standards Code. So it goes by where the employee, where it's basically the way the code is written, it's where the work is being done. So it's really where the employee is located. And again, I'll reiterate with just cause, notice is a legal right. So just cause as an exception is something where the employer really does have a duty to document things, keep track, and substantiate this. It's quite a serious, seen as a serious thing. And by the way, I just want to make it clear too. An employer can have a good reason for terminating that doesn't rise to the level of just cause. So when I say maybe you don't have just cause, it doesn't mean you don't have a good reason. Someone can be a bad employee and you can have every right to terminate them, but it doesn't mean that you have to claim just cause. Just cause is for very serious situations as an exception to notice. Let's jump into overtime and hours of work. So the standard hours of work are 8 hours per day, 40 hours per week. There are a few exceptions that we'll sort of get into. Construction, certain construction has some exceptions. Landscaping has some exceptions. But generally, these are every employee in Manitoba outside of that. So employees who work more than standard hours are entitled to overtime wages. Overtime wages are time and a half, so 1.5 time. I just want to remind everyone, and this is as per Melena's earlier question, things like part-time, full-time are not language used in the Employment Standards Code. It doesn't matter what you define the employment relationship as. If your time goes above 8 in a day, you're entitled to overtime pay for the time over 8. Same with weekly hours. So again, landscaping, construction, there's another exception. Some places have averaging agreements where employees have agreed to work like 4 days in a row, 10-hour days, and then have 3 days off. That's okay. You can set that up and there's no overtime owing. You can do that. But that agreement would have to be in place. And if it's a larger amount of employees, you may need to have an averaging permit, which you would apply for through employment standards. Just a note about overtime. It's 1.5 times. Overtime does have to be agreed by the employer. An employee cannot say, hey, I worked, 12 hours yesterday. You have to pay me 4 hours of overtime. The employer and the employee do have to, overtime is supposed to be something that the employee and the employer agree to. So the employee cannot just secretly work a bunch of overtime and then claim that, right? Now, that said, if an employer knows that you're working 12 hours, we would see that as agreeing to it. If they're aware of it, then it might be something that that an employee is entitled to. Employees cannot be required to work overtime. You can't put that in your job agreement. Hey, we need you for 60-hour weeks. It's illegal according to the Employment Standards Code. An employee has to agree to it on an ongoing basis. This is an interesting one that a lot of people don't know. Even if you're paid salary, even if you're paid commission, incentive pay, you're entitled to overtime. So if you have a person who makes commission on sales and they say, hey boss, can I work 12 hours today? And the boss says, sure. We would consider that commission as paying for the 8 hours, and then 1.5 times the commission is required to pay for the 4 hours overtime. So keep that in mind as an employer, especially. You don't skip over overtime by having a salary agreement or a commission structure. Overtime still applies. So you still need to make it clear to your employers how much overtime should be being worked. You can pause there for any questions.
Hi, I have a question.
Sure.
So can a collective agreement override overtime rules?
Again, employment standards doesn't comment on collective agreements. The only thing in the code is that collective agreements cannot undermine minimums in the code. So a collective agreement cannot say, for example, as far as I know, a collective agreement, but talk to your union head for more information here, but a collective agreement, as far as I know, cannot say, employers don't have to pay for overtime. That would be illegal.
Okay, I also have an example that I want to share.
Sure.
So what if an employee wants to do makeup time in the second week in the same pay period for the time missed in week 1?
Yeah, and that's something we let me just check here if I have it in my notes. I can't remember. I think it's no, I don't think so. So let me mention that you can have a banked time arrangement. You can bank overtime, and what that means is that if an employer and an employee agree, you can count overtime. You can basically bank it as time and then take that time off in the future. The caveats there are banked time has to be banked at 1.5 time. So if you work overtime for 8 hours, if you work 8 hours of overtime, then you are owed 12 hours off, just like it's paid out 1.5. And banked time has to be used within 3 months. But the answer would be yes. Within a week, you could certainly bank overtime and then take it as a day off. I'm going to just jump into Nasir's question here. I think it was next. Why employers offer for employment or independent contract position instead of full-time employees? So this is separate from the overtime. We'll jump back into the overtime in a minute, but I do want to deal with this because it's an important question. And it's a complex question. So as I said before, contractors are not subject to the Employment Standards Code. We see this as a business-to-business relationship. But whether or not someone is a contractor or an employee, it sometimes comes up in claims. It does not depend just on the initial agreement, right? An employer can't just say, oh yeah, I consider these employees to be independent contractors and they pay their own taxes and stuff. So the advantage of hiring an independent contractor is that they would control some of like the marketing. They would potentially have their own tools that they bring. They control their schedule. And then maybe you don't have to pay them benefits, and you don't have, they take care of their own taxes and stuff. So it's just a different relationship. An independent contractor would be, for example, if I hire a plumber to come to my house, that's not an employee. The plumber is their own business. And at an employer, if you, for example, a trucking company hires an owner operator trucker, the trucker controls their own truck, they control their schedule, they take on jobs. Now, that said, an employer cannot just say that someone is a contractor. If we get a claim from an employee and we have to determine whether someone's an employee or a contractor, we take into account the nature of the relationship, not just the initial agreement. So employment agreements typically mean that the employer controls the schedule, the employer controls how much money the employee makes, even if it's like commissions or something, that's still an employment agreement. The employer, you know, provides the location and tools and stuff. That would be like a typical employee relationship. You don't have to have all those factors, but usually these are more like sort of case by case, where like if it's mostly an employment relationship, we see it as an employee. If it's mostly a contractor relationship, we see it as a contractor. A contractor would generally be someone who controls their own business. They could hire people if they wanted to help. They could work for competitors, no problem, right? So if you're trying to say like, hey, we want you as a contractor, but you're going to work 8-hour days, you're going to be paid, or 40-hour weeks, you're going to be paid this amount, and you can't go work for someone else, that's an employee relationship. So you really should handle it that way. So hopefully that clarifies a little bit of that for Nasir. Potentially you could hire for a warehouse position. That would be a little bit unusual, I think. It would be hard to establish that the warehouse person is their own business entity as a contractor, and that they're just like picking up warehouse shifts with you. That would be very unusual, I think. Did anybody else? I think Rami, you had a question. I can go ahead if you want.
Yeah, it was regards overtime. The 1.5 times overtime wage for a salary management. Does that apply the same way, or
That's a
management?
yeah. That's a great question. And the code is specific. There is an exception to standard hours of work for management employees. And you'll have to excuse me, I'm using these cough drops. I had a cold this week, so that's why. Management employees are exempt from overtime and standard hours of work, according to the Employment Standards Code. So there is no overtime for management. Now, I should clarify, the code states that this applies to employees whose job is management functions primarily. So if someone actually manages other employees, maybe manages buying and selling, payroll, things like that, and that's like 80% of their job, this exception would apply. It doesn't mean, just like the independent contractor thing, it doesn't mean that you can call an employee a manager, like a retail sales manager, and that they don't get overtime. If we got a claim for this, we would have to investigate whether that person was most of their job as a manager, or were they really just a salesperson, or a, you know, do they handle customers? So there is an exception for this, but it really requires the person to be doing management functions as the primary role.
Thank you.
You're welcome. We'll move on. If anybody has any other questions, please let me know. Reporting pay. Reporting pay is in the Employment Standards Code. If an employer asks an employee to come in for a shift that is 3 hours or more, and then like there's no work or whatever reason, the employee comes in and the employer says, sorry, we don't need you, the employee is entitled to receive that 3 hours of pay. This is true for indeterminate shifts as well. If the employer's like, hey, we need you, we don't know how long it's going to take, and it takes an hour, the employee is entitled to 3 hours of pay. If the employer schedules you for 1 hour and you come in for 1 hour, go home, the employee is only entitled to 1 hour, right? So if it's clear that they're bringing you in for X amount of time, you're only owed X amount of time. But if you're supposed to be or could be in for longer and then you're not, you're owed reporting pay up to 3 hours. Please let me know if there are questions about reporting pay, because I know sometimes we do get a lot of questions about this. This is very common in the restaurant industry as well. I should clarify, reporting pay is not owed if the employee is given notice that their shift has been canceled before they report for work. Even if they get a voicemail while they're driving on the way to work, we would see that as you've been notified, so you're not owed reporting pay. It's only if you report to work, and of course, if you work a little bit, then reporting pay applies. And if there are no questions,
Oh, there is one in the chat. So someone said, what if it's a scheduled staff meeting or training?
yeah, good question. So it doesn't matter what it is. If it's scheduled, the employer owes the scheduled time. Actually, I'll give you another example. So that applies to training, staff meetings, everything. If you schedule a staff meeting, the staff meeting's 45 minutes, and you schedule it for 45 minutes and it takes 45 minutes, you don't owe reporting pay. But if you schedule a staff meeting for 2 hours and it only takes 1 hour, you and everybody's done, you owe reporting pay up to the 2 hours. Right? So reporting pay is 3 hours if it's scheduled for greater than, or if it's indeterminate. But if it's scheduled less than 3 hours and the person works less than that, you do owe up to whatever the time was scheduled for. So that's seen as the same as reporting pay. Hopefully that makes sense. So if you schedule for an hour, the person works an hour, you pay an hour. If you schedule for an hour, the person works half an hour, and then the employer tells them to go home, you owe the full hour still.
Even if it is mandatory, like the staff meeting?
Well, I would assume that all of these examples are mandatory.
Mandatory, okay.
If it's not mandatory, maybe it gets a little bit more complicated, but these are examples where the employer is basically asking the employee to work.
Yep.
We'll move on, but let me know if you have any other questions. Feel free to share. Some information about breaks and day of rest. So day of rest is basically employees are entitled to 1 day off per week. Now that can be any day, it doesn't matter, but legislatively it has to be offered. Employees are also entitled to a break, 30-minute break for every 5 hours worked. So after 5 hours, you're entitled to a break. The break doesn't have to be paid. So that's why normally, like a normal 8-hour day would be 8 people would be there for 8.5 hours and maybe get a half-hour lunch. And then often the employer will give an hour for lunch and half hour of it will be paid or something. But employees are entitled to this. If it's to be a true break, employees should be free and clear of all duties. If someone, we've had claims where maybe an employer is saying, oh yeah, they get breaks, but the employee says, well, I'm kind of on call. It's a restaurant and like I am getting a break, but if a customer comes in, I have to handle it. That's not a break. So we might, if we got a claim like that, we might say, hey, they have to be paid for this half hour. They worked through it. There are certain exceptions to this only in the case that an employer applied for like a work break order through employment standards. There are certain employers, and it's sometimes restaurants, sometimes like home care and things like that, where the employer will say, hey, they can't take breaks. They have to be doing something all the time. And then we would approve that as long as it was clear that the employer was also offering some kind of benefit to the employee for the situation. Like they could take breaks whenever they want, and we'll pay for those breaks. So there are situations where you can apply for like a work break order, and the 5-hour break will be waived by employment standards. But generally, all employees are entitled to 1.5 hour break per 5 hours worked. And you can, of course, offer additional breaks. Most employers do. We can open up another big topic, vacation. So these are kind of two separate things, vacation time and vacation pay. Employees begin earning vacation on their first day of work. So all employees are entitled to vacation, whether you're part-time, whether you're on in your probationary period, no matter what, you're an employee in Manitoba, you get paid vacation wages. Employers can choose to pay out vacation wages on every check, or they can pay out vacation wages when someone takes their vacation time. It's up to you. You can do that both ways. And we'll look at how that's kind of calculated in a minute. I should note, if you are an employer who pays out vacation wages on every check, you are still responsible to make sure employees are getting their vacation time. Their vacation time won't be paid because it's already been paid on every check, but they still are entitled to the time, which is normally 2 weeks. 2 weeks is the minimum standards of vacation, 2 weeks per year. In the 5th year, that increases to 3 weeks. If you're looking at calculating vacation wages, it is 2% per week of gross regular wages. So if you're paying out vacation wages on every check, you would pay 4% for a 2-week entitlement of the employee's gross regular pay per check. Gross regular pay means it doesn't include overtime, for example. And then in the 6th year, you're responsible to start paying 3 weeks or 6% and the back pay for the 5th year, 3rd week. Questions about that? I know vacation wages can be a little bit of a complex topic. Yeah, Stacy asked, what if employees choose? That's okay. I would just make sure to document that, perhaps, just in case the employee comes back and says, oh, I wasn't offered it. If the employee, like, you can't, to be honest, the employer under the code can force vacation, basically, as per the code. They can say, here's your vacation. If the employee really doesn't want it, I guess I would maybe just document that. But you are within your rights to say, well, this is your vacation. Just make sure that you're paying the vacation wages in that case as well. Like, just pay out. You can. By the way, you can also pay out vacation wages. This happens at termination often. You can pay out vacation entitlement using this 4% figure, even if you usually pay vacation at the time of vacation and you have a bunch of vacation accrual. You could just take all that vacation accrual and pay it out based on their length of service, 4% of those gross wages when they get terminated, for example. So you could do that as well. Next slide talks about this a little bit more. So overtime and like bonuses and stuff is not included in vacation. Regular time and general holiday time, like the day off for general holiday, is included in vacation pay. So employers do have to give employees their annual vacation time and pay within 10 months of it being earned. So typically that means within 10 months of the end of the year in which the vacation was accrued. So we look at that as like a 22-month period. So that would be the day on which an employer is responsible for making sure that vacation time has been taken and vacation pay has been paid out. This gets a little awkward. An employer can set a yearly date for vacation as long as they communicate that to employees, or they can use the employee's own start date. You're within your rights to do it either way. That's fine. And this, I guess, references Stacy's question as well. in the code, if an employee and an employer cannot agree on when vacation can be taken, the employer can give 15 days notice. And here's your vacation. The employer does have to offer vacation in weekly chunks. By the way, you can't give them days, individual days. You have to give them a week at a time, or 2 weeks or more. But please let me know if you have questions about any of this.
I think Amanda has her hand up.
Sure.
Yeah, I'm just wondering if you can clarify maybe a little bit further regarding the annual vacation within 10 months of being earned. And then you said 22 months. Is that like when it is recommended then for employers to make sure that it's either being paid out or taken? I'm just trying to get some vacation policies in place, and I'm
yeah,
kind of struggling at ground zero here. So
it's tricky because it is a rolling date, right? So it's obviously always, an employee is always accruing vacation. But if you want to simplify it, an employee's first, if you want to think about when the employer has a responsibility to ensure something is done by, an employee's start date, 22 months after that, the employer is on the hook for all the vacation, sorry, not all the vacation. 22 months after an employee's start date, an employer is on the hook for vacation earned in the first 12 months. So the reason I say it's awkward is because it is a role, like they're obviously still accruing vacation, but just if you want to try to make some strong policy around it, I would say that like you can pass off some of this responsibility, not all of it, but you can say that some responsibility exists for an employee to try to ensure that their annual vacation is taken within 10 months of it having been accrued. In other words, within 10 months of the end of their year of employment. So if I work from, say, November to November, I now have my 2 weeks of vacation. You basically have 10 months after my anniversary date to make sure that I can take it or it gets paid out. I know that's not a perfect answer because it's still like, if you have more questions, feel free.
I'm just trying to make sure that I'm seeing this clearly. So let's say an employee, it's, employee's responsibility to use it within that 10 months. So then that makes sense now, the 22 months, as you said. Maybe from that point, if it isn't used by the end of that calendar year, the employer has the right to pay it out or give that 15 days notice to schedule your vacation.
Yes, and that is the point I want to harp on a little bit, because I've seen employers say, if it's not used within this 10 months, you lose it. Can't do that, right? So what you have to have is an end date that says, on this rolling like 22-month period, we're going to pay out that first year. If it's not used by then, we're going to force you to take it or something like that and pay it out. That is an employer's responsibility. And a question from Robin too. Can you pay out accumulated vacation pay? Yeah, I think you can. You can. Technically, the employer should be ensuring that the employee takes it. Again, if they really, if they refuse to take their vacation, I mean, I would just make sure to document it. But technically, you can also say, well, sorry, here's your 2 weeks vacation. The best way you can cover your bases is definitely to make sure that it gets paid. But don't forget, you don't technically owe it until the 10 months after the end of the year in which it's been accrued. Hopefully that answers some questions. And yeah, if an employee refuses to take their vacation, you still do need to pay out the vacation. You can pay it using that 4% figure or 6% if it's after 5 years. But you should try to ensure that employees are taking their vacation. And if they really don't want to, you are within your rights to schedule it for them. And let me know if there are more questions about vacation too, but we'll move on to holiday pay. General holidays, sometimes people call these stat holidays. That language is not in the code. In the code, it's general holiday. There are 9 of these now, with Orange Shirt Day having been added this past September 30. There are no more than this. We will talk about Remembrance Day as well. Remembrance Day is technically not a general holiday. It's its own separate thing, but we'll talk about that in a moment. Now, with general holidays, these are legal holidays, so employees have to have the day off. They would either have the day off, so this can be complicated, but let me try to explain. All employees would receive pay for the day off. That pay would just be a normal day. And we'll talk about that in a sec. If you want to calculate what a normal day is, we see it as 5% of the previous 28 days of work, 5% of the gross wages over that previous 28 days. That's the general holiday pay. If it's someone who works the same every single day, then it's easy, just pay them that. Employees who agree to work on a general holiday are also paid time and a half for hours worked on a general holiday. Employees who work on a general holiday are paid that time and a half and the time for the day off. Sometimes people call this double time and a half, but it's not technically double time and a half because the hours they work could be different from the hours they typically work. So you could come in and work only 2 hours on a general holiday, but all hours worked on a general holiday are 1.5 pay. All employees receive time for the day of the general holiday, the day off. A small note, general holiday hours are considered hours worked even when you have the day off. So those do count towards standard hours of work for overtime. Like if Monday is Thanksgiving, so I have Monday off, I work Tuesday, Wednesday, Thursday, Friday, and I work 8-hour days. I worked 40 hours in that week, not 32. And I would receive my 8 hours pay for Thanksgiving. And if my employer asked me to come in on Thanksgiving and I agree, whatever I work, I would also receive time and a half for that time. There's a question, Anu?
Yes. So what happens if a new employee starts working a week before any of these general holidays? Are they entitled to a full day of holiday pay or 5% of earnings for that 1 week that they worked?
Yeah, and I think they are entitled to it, but not a full day of pay. So the 5% is how we kind of prorate this. 5% of the gross earnings over the past 28 days would kind of like automatically prorate this for you. So technically it's just that 1 week of work, 5% of that. Rami, did you have a question?
Yes. And how about if the company creates additional holidays? Let's say we are open Monday to Saturday, over Christmas week. We will be closing 24, 26, and 27. That not everybody works full time. Does that count as our liability to pay out a full day for the part-times that usually would work, let's say on the 26th? Or
Yeah.
would we pay them stat holiday?
It's a good question, and I think I can answer it like based on what you said. Like those would not be considered general holidays. An employer can certainly have policy that, and often do. Most people are paid more than minimum wage. That's an example where an employer is basically giving a greater benefit, which of course is fine. You can do that, but it wouldn't be like enforceable under the Employment Standards Code necessarily. You could have an agreement and policies that state whatever you want, but you're not required to pay those days just because you've said that they're holidays. The legal requirement would be that you have to pay out Christmas and New Year's because they're general holidays. So these 9 general holidays are the only days that you have to handle in this way. You're within your rights, like the employer controls the schedule. You're within your rights to have a shutdown week or a couple days off at Christmas where people are not brought in, and there's no legal requirement for you to pay for that. Does that answer your question?
Yes, partially. Yeah, it does. But I have a second question. So
Sure.
even if those are full-time employees, in that case, we would pay the 3 days that we are closed. Is that correct?
You can if you want, but you don't have to by law.
Okay, thank you.
Yeah, you're welcome. Yeah, you have to pay just the Christmas and New Year's dates. You do have to pay those out. And of course, you can have policy where you do pay them out, and many employers do that. Yeah.
All right, sorry, there's just one more question in the chat, but then I just want to remind everyone we do have 15 minutes left. So I kind of want to allow John to get through his presentation, but I think Stacy has a question. It's if we include GH
Yeah.
with every check, as we do for vacation pay, then the week with Thanksgiving would be 4 days a week, not 5, being that the Thanksgiving day has been paid among all pay periods. Can you
Right.
confirm? Okay.
Yeah, and that's something that you can actually technically do if being in construction. Construction can pay out general holiday on every check, and then they just don't worry about the general holidays at all. I'm not sure that you're kind of allowed to do that outside of construction. I might have to get back to you on that. And I don't know if you have like a contact or something that you're comfortable sharing, or an email. Maybe you could contact privately or let Milena know, and I can maybe contact you to suss that out. And Rami, did you have another question too?
No, I think my hand was just.
Oh, okay, no problem. Okay,
Sorry.
we'll move forward here a little bit. And as stated, the general holiday pay is, of course, you could pay someone with a normal schedule, just a normal day. But if you do want to calculate it, it's 5% of the gross wages for the time before a holiday. If employees miss the last shift before or after the holiday without informing the employer, like it's a no-call, no-show. So this isn't like a sick day. This is like them not showing up for a shift. This exempts an employer from having to pay out the general holiday under the code. Yeah, so if they're on a protected leave or sick or something, that doesn't apply. They've notified. And I'll grab Stacy. I'll grab your contact info there too. Working on a general holiday, we kind of covered this, but 1.5 times regular wage. There are some industries that are exempt from this, and their wages are just paid regular for the day, and they're given a different day off. These industries would be continuously operating businesses, like 24 hours a day, like hospitals, perhaps wellness clinic applies there too, restaurants, hotels, gas stations. Just to note that Orange Shirt Day is special in that it cannot be substituted in this way for a different day off. You do have to give that day. And I do see Ram has a question there too. If you have a shutdown, how would you calculate pay for part-time employees or employees with fluctuating hours? Pay for the 5% figure applies for all general holidays. So if there's a general holiday, you would, and of course shutdowns, like if you want to pay for other days that are not general holiday, then that would be up to you how you want to handle that.
There is one more question as well. So Shannon asked if you referred to an employee being entitled to general holiday if they are sick before or after the holiday. What happens if they are sick consistently before or after a holiday?
Yeah, and I'm going to look at the legislation here, like just to give you a better answer, but Let me just check. I'll be 2 seconds here. This is in our fact sheets if you ever want to look it up, but so the only way that you would be exempt from general holiday pay is if an employee is scheduled to work, but you're absent. So it's basically absent without employer's permission from the day before or after the holiday. So it gets tricky because it could be someone calls in sick and they don't have permission. As long as it's outside of those three days you get for family leave, potentially this could be something where you don't owe general holiday pay. So you're basically saying like you have to come in, sorry. That would be considered without permission. So permission is really what the legislation turns on here. Let's move on a little bit here into working. A few considerations. So these are just some things. General holidays that fall on weekends, they still get a work day off. I think most people know that, right? If Christmas falls on a Sunday, you still get a day off. When it falls on a weekday that an employee does not normally work, they still get a day off. If someone never works Mondays, then the general holiday on Monday is still supposed to be a day off for them, another day off for them that they get paid for. And we talked about this. An orange shirt day cannot be substituted at all. So we'll move on from general holidays a little bit, talk about Remembrance Day is very similar. It just has its own separate legislation. Most industries are not allowed to operate at all on Remembrance Day. Those that can operate are listed here. There are some more. You can look this up online, industries that are allowed to operate on Remembrance Day. Retail businesses can be open, but they can't operate between 9 and 1. Staff that do work, staff that don't work Remembrance Day are not paid. That's a big difference from general holidays. Remembrance Day is not like a general holiday that you have to pay. If someone doesn't work the day, you don't pay anything for this day. Staff that do work are paid like a general holiday, 1.5 times regular wage and general holiday pay. So it's like the 2.5 times. There is a requirement for employees, if they're called in on Remembrance Day, to work at least half of their normal hours. So you can't call someone in for half an hour or an hour if they work an 8-hour day normally. But I would encourage you to, Remembrance Day only comes around once a year. It's already done. So next year it comes around, I would encourage you to take a look at the fact sheets on employment standards, as I do myself whenever it comes around, because it's not common and there are a few little specifics with it. I do want to get into this because this is a fairly big topic, protected leaves. This is something covered by the Employment Standards Code. And what a protected leave is it's unpaid, it's required, it's a right that an employee has. They can invoke a protected leave and the employer cannot terminate them or affect their employment negatively due to the leave. Right. So what would happen normally is that an employee would invoke a leave, they would get time off. There are various leaves here. You've heard of some of them, I'm sure. Maternity leave, parental leave, long-term leave for serious injury or illness, family leave. Family leave is what most people call sick days. That falls under family leave. Bereavement leave. There are a bunch of them that we'll look at in a minute. Employees must be allowed to return to the same job they had prior to the leave. If that's no longer available, they must be given similar position with same or greater benefits and pay. Right. Normally, people know about this with mostly with respect to parental leave, because it's one of the longer leaves, but it applies to all leaves. Right. Employers are not required to pay wages during leaves. They certainly can, and most employers do have policies for paid sick days, for example. But employment insurance is something that comes into play for longer leaves, like long-term injury or parental leave. Employment insurance is not something employment standards handles at all. It's handled specifically through EI. I should mention an employee's period of employment doesn't end while on a leave. They're still considered employed. They cannot be terminated for taking a leave or while on a leave. This would be seen as a gross violation of the Employment Standards Code. It would be a claim issue, and we would investigate that. If an employee came to us and said, you know, I was terminated while I was on parental leave, we would investigate that. An employee cannot be terminated for intending to take a leave either. So as long as they're entitled to the leave, if an employee says, I was injured, I hurt my knee, I don't know if I'll be able to work, and the employer says, oh, you're fired, just because they haven't invoked the leave yet, we might look at that as, okay, they found out about the injury, clearly they're intending to. So just as employers, be careful about this. This is something where you do have a legal responsibility to respect people's entitlement to protected leaves. You can terminate someone for other reasons, like if you're intending to terminate someone and then they say, no, I'm taking stress leave. You can still terminate them as long as you are not terminating them for stress leave. Right? So if we got a claim from an employer who said, I was terminated for taking stress leave, we would investigate. And if we were satisfied that, sorry, the employer terminated you for other reasons, they terminated you and they were intending to terminate you for other reasons, that would not be a leave violation. So you could be terminated while on a leave as long as the reasons for that termination have nothing to do with the leave. Qualification for a leave is different for every leave. I would encourage you to take a look at the fact sheets on protected leaves for this. There's usually like a length of time you have to be employed for, like 7 months or something. You have to meet the requirements for the leave. If you take parental leave, you have to have a baby. You can't take parental leave if you don't have one. You have to tell your employer which leave that you're taking. Of course, you just have to commit. You don't have to say like, I am taking long-term protected leave, because some people don't know the names of all the leaves. As long as the employee is like, I'm injured at work, my doctor said I have to take 2 weeks. That's sufficient for us to say that the employee has communicated that they want to take long-term leave for serious injury or illness. So you don't have to know all the leaves as an employee, but you do have to communicate what's going on to your employer, right? You can't just disappear. The employer is within their rights to ask for proof in some of these cases. As per COVID regulations, an employer cannot require a doctor's note anymore. You can ask for a doctor's note, but you can't require it. But you can require reasonable verification, and then it's up to the employee to figure out what that means. So if someone injures themselves and says, hey, I need 2 weeks off, you might say, hey, well, can you verify this for us? And the employee can say, hey, the easiest way is a doctor's note. And that's normally how that happens. The employer just cannot legally require them to go get a doctor's note. And that was changed due to COVID. I guess employers sending employees in to get doctor's notes and spreading COVID. So that's still in place. So there's some definitions of what family leave, what that includes. That's something I think you can look up on your own. Employers don't. Yeah. And
there's just a question in the chat.
Just to finish that before we get to the
question.
Of course. But employers don't control when the leave happens, by the way. This is important. An employee, if they say, hey, I'm taking a family leave day, the employer can't say, okay, take it on Friday. It's up to the employee to control when this is taken. So let's look at some questions here about this. Reasonable verification. Yes, this is a sensitive one and a tricky one. I don't know, is my answer. It would be whatever, like a lot of things in employment standards do come down to kind of like reasonable verification and what sort of a reasonable person would think counts. I would certainly say that a doctor's note or comment on this. Hopefully people maybe don't find themselves in these situations. I'm assuming that in a situation where this occurred, the employer was probably like maybe aware of the pregnancy already, so they would not probably be asking for verification. But if it was a situation where maybe the employer wasn't aware of it and they have doubts that this is even true, that situation could unfortunately become a little bit complicated. And it's something that maybe I would maybe call our GI line to maybe sort it out with an officer what might be applicable in the specific situation that you find yourself in. And I would say that to everybody here too, as employers or employees. The Employment Standards Code is legislation. It's clearly written, but a lot of specific employment situations are not always clear and simple, and context matters a lot. So I would encourage you in various contexts or situations that you find yourselves in to feel free to call our general inquiry line to kind of get help or advice on this, because that's something we might have a little bit of advice for you depending on what exactly took place. And yeah, I'm sorry I can't give like a clearer answer on this one. Were there any other questions or comments?
No, none in the chat box.
We can jump into leave. So I won't belabor this too much, these leaves. You can look these up what they are, but most people know about a few of them. Maternity leave, parental leave, family leave. Note that you're only entitled to 3 days of family leave. Some people are surprised at this. Most employers have a sick leave policy that is a greater benefit than this. That's very common. But technically, an employer is within their rights to discipline someone for taking a sick day over and above their 3rd day in a year of family leave, right? So you could say, like, you know, we don't accept, or you can't take a sick day or something like that. And the employee, then of course it's up to you how you want to handle it, but technically employees are entitled to 3 days, sick days, family days per year. Bereavement leave, compassionate care leave, long-term leave for serious injury or illness. This has recently been extended to 27 weeks. These leaves have to be continuous. You cannot break them up into periods, by the way. Interpersonal violence leave, leave for citizenship. So for citizenship ceremony, you can claim a leave for that. Reservist, death or disappearance of a child, organ donation, critical illness, COVID vaccination, you can claim 3 hours for this as well. And for bereavement, is it paid? I don't believe so. I don't think bereavement is listed on here actually. Oh, it is. Yeah, it's just like a normal leave. I don't believe that it's paid. We can jump into just a little bit about young employees. Just a reminder, if you don't know, anyone under 16 years old, so 15 or lower, do have to complete a Young Worker Readiness Certificate course. I've taken the course. It's really good. It's basically informing them of their rights and responsibilities as an employee. And you have to have that certificate as an employer. You have to have that certificate from an employee if they're 15 or under. Over that age, don't have to take it, but there are some code restrictions over who can work and when. Under 18 can't work alone at night. And they can't work in certain industries like asbestos removal, things like that, mining. There are certain industries listed in the code that they can't work in. Under 16 have more restrictions. They have a maximum of 20 hours per week. And again, they can't work in certain industries. Here are some examples of those industries: forestry. I mean, all of the ones that apply to 18 apply to 16 as well, but 16 and under have more. tree removal at height. And note that under 16 require adult supervision. They can't work alone. They need an another adult worker with them at all times. This is the last part of the presentation, and I'll go over this very briefly. RAPA, Worker Recruitment and Protection Act is something that we enforce at Employment Standards. This is newish legislation in 2008 designed to protect foreign workers. It also is designed to protect child performers. It includes both. Generally, this includes nowadays child performers and people on a temporary foreign worker permit. And it basically prevents fees for licensing and stuff being charged by agents and employers to temporary foreign workers and child performers. So there are rules that employers have to follow when they want to recruit people in this consideration. So the purpose of this act is to prevent, the purpose of the act is really to protect vulnerable workers. And this is done basically through employment standards registering and licensing businesses. So essentially, if you are a business who's recruiting temporary foreign workers or child performers, you have to apply through employment standards with a business registration under RAPA. And employment standards will approve or deny that registration. And then you're registered, and you would obviously still be responsible for ensuring that fees are not paid by these people. They would have, like, temporary foreign workers would have a work permit, and they would have an employment agreement that has to be respected, etc. Any questions about this? I know this is a really big topic. I'll give you a little overview.
One question.
Sure.
So someone in the chat's asking if an employee doesn't submit their timesheet for approval, can they be paid the next payday?
Oh, well, technically, an employer, just under the code strictly, an employer is required to pay for hours worked on the next payday. So this is more an employer issue that we wouldn't get involved in. The employer's having trouble figuring out what the hours worked were. The employers, we would say that the employer has an onus to figure out what those hours were. Practically speaking, I mean, yeah, if you're requiring employees to submit timesheets and they won't for some reason, you might communicate to them like, hey, if you don't, you might not get paid. But by the strict reading of the law, the employer is required to pay for those hours, whether they know what they are or not. They're required to pay for them in that pay period. But practically speaking, of course, you might have a conversation with your employee and try to figure out how to make sure that those hours were paid. A little bit more about RAPA, but it handles licensing, registering, permitting, fees. Basically, we handle like taking business registrations under RAPA. All of this is to regulate employment agencies like immigration consultants, temporary help agencies, child performers, recruiters, businesses hiring temporary foreign workers. So all of these entities are beholden to RAPA legislation. And this, as an employer, would basically apply to you if you're interested in hiring temporary foreign workers or child performers, insofar as you would want to then apply for a business registration and understand the rules around that. As an employee, it would apply to you if you are a temporary foreign worker and wanted to, to know the laws around that, or if you're a child performer. We don't get as many of those nowadays, but temporary foreign workers, basically, if your recruiter is saying, hey, we'll get you this job, but pay us $40,000, that's a violation of RAPA, and it's something that you should contact Immigration Canada and Employment Standards about. So as I said, this is something where if you want to hire temporary foreign workers, you have to register with us. And then you get issued like a LMIA from Service Canada. A question, if you put an ad on Indeed, great question, great question. Yes, I would say only if you intend on hiring that person that you would have to apply, yeah, or you would have to register. And sorry, let me make this clear. This would be a little bit unusual because typically a temporary foreign worker is on a closed work permit. So they already, like the business has reached out to them. If it's someone applying for jobs, they probably are on an open work permit and are not a temporary foreign worker, but they are just working and living in Canada, which would mean that they are not under RAPA legislation. So if they are on an open work permit, no, you don't need to register. If they're on a closed work permit, they should know already what business has contacted them and where they're supposed to be working. And then there's some information that happens when you are interested in applying for those what we call BRs, business registrations, for hiring temporary foreign workers. Who's requesting them, who's involved in the recruitment, what jobs you're hiring for, and how many workers you need. And just a note about RAPA, it prohibits fees being charged to workers. That's its primary function. Licensing temporary foreign workers, child performers, you cannot charge fees for the process. It is illegal for someone to say, "Hey, I can bring your cousin over from England for $10,000." That's RAPA expressly forbids that. Child talent agencies have a special exception under this as well. And this is a really interesting question. If they're hired on an open work permit, now need an LMIA and get a closed work permit too. Yeah, if that happens, I think Ibukun is asking like, yes, there can be a shift. I don't understand a lot of this because it's handled by Immigration Canada, but my understanding is that there can be a shift in your work permitting, like as a temporary foreign worker, or you can go from being a temporary foreign worker to an open work permit and vice versa. If that occurs, I think open communication is important, and the company to whom you are employed may be required to register. So that's a really important question, and it's something that the employee and the employer should try to inform each other about what's going on, because there is information out there for sure. Like call Immigration Canada, call Employment Standards, and figure out what needs to happen. I do think I do still have time, by the way, if people do have more questions, but I want to show you some resources here. This is our general inquiry line, this phone number. You can find it online as well. We're open 8:30 to 4:30 every weekday. We have an email address as well. We also have a website. The website has fact sheets on it. If you search in the top corner of the website for termination or for protected leaves, the fact sheets are really, really good. They're basically plain English versions of the legislation. The legislation itself is online as well. If you want to look it up, you can find the Employment Standards Code. I would encourage you to maybe look at that first if you ever have a question and figure out if you can answer it that way. Otherwise, feel free to email or call us, and we're happy to answer more questions. So I see that Melinda has posted something as well.
Yes, that was me. So I don't think there are any other questions in the chat box, at least. But if anyone has questions, you can feel free to unmute yourself as well. But thank you to everyone who joined this webinar. And thank you so much, John, for having delivered this insightful presentation. Yeah, so what I included in the chat box was just upcoming webinars and events that we are holding in the next few weeks. So make sure to check those out. But thank you so much for your time, and we hope to see you soon.